NACDL is the association of the nation's criminal defense bar.
I have the fun task of talking about ethics at the end of the day on the first day, which is why you're all here. This is what I hope doesn't happen today. And I'll tell you this story real quick. Several years ago, I picked a jury. And we spent a day and a half picking a jury. And as I thought it had gone well. The jurors and I were talking, we were having a nice dialogue. And I turned around to pack up my stuff to leave, and this was the sole spectator in the courtroom. That's what he thought of my voir dire. I asked the judge, who thought it was humorous as well, if I could take a picture. So I'm hoping this doesn't happen. One of my friends from Cincinnati is right here in the light blue shirt. Hal likes to sleep at every CLE he goes to. So if any of you catch him sleeping, let me know, because we need to take a picture and put it on Facebook. That's how we shame each other. All right, so I'm going to try to keep this somewhat entertaining, but give you some substance about ethically persuading your jury. And when I first did this a couple years ago, I was asked to do the topic, and I'm going, what the hell kind of ethics are there in voir dire? I mean, we never think about it that much. But when I got into it, it was kind of interesting. But what I think you have to start off with is, what are we trying to do in voir dire? All right? Starts with your theory of defense. If you don't know where you're trying to go, you can end up with the wrong jury. I think we would all agree, this is an older photograph, but Michael Vick might have a problem if that's his jury, okay? And we laugh at that because we've had juries like that, right? Well, how do we avoid that? Well, Dave Chappelle gives a great example. Now, this is a clip. If you've seen it before, don't give away the ending. It's very funny, but it is also very, very instructive at the end of what kind of ties up everybody's presentations today of what you're trying to do in voir dire. And we're going to talk about social media and some other things to do so that you can do it and not get in trouble ethically. So what we learn, right? It kind of ties together a lot of what we've heard today. Reasonable doubt is different things to different people. Think about what Clay told us about in talking about jury nullification. Find a reason for them to acquit your client. It doesn't have to be a legal reason. It can be any of these reasons. And there's so much truth in what he talked about that when you pick a jury, you have to try to find that information about these people, your jurors. So what are the goals of voir dire? Establish your theory of defense. I think that's the most important thing you can do. Eliminate jurors that are unwilling to consider your theory of defense. One of the things that the prosecutors in Cincinnati like to do is stand up and say, we're here, we'll pick a jury, we want a fair and impartial jury. We all know that's bullshit. So I stand up and go, that's the first thing they lied to you about. They do not want a fair and impartial jury. They want 12 police officers who have all been victims of a robbery. They don't want 12 people who've been falsely accused, do they? And all they're just go, oh yeah, I get that. Call them on their crap. Because that's how you do what other speakers have talked about. You become the leader in the courtroom. You become the one they look to for help. Trying to get them to be honest. Regardless of your political views, whether you are pro-Donald Trump or not a Trump supporter, the one thing that has helped the criminal defense bar is Donald Trump. He has given jurors the right and the privilege and the permission to reveal their true colors. Absolutely. I tried a case a few weeks ago, and the judge asked, does anybody have any physical, mental, whatever reasons you can't serve? One of the early questions. What's your problem? I'm not a racist, but. Now, we all know what came after the but, and he would still be talking if we hadn't cut him off. All right? But he was very proud to tell us about his life experiences. And when you look at his juror questionnaire, he had been jumped 3 different times. Now, anybody could be jumped once. It could happen. 2, maybe. When I saw the 3rd time, I'm going, he got his ass beat because he deserved it. Right? Isn't that what we would all think? And when he came in, that's exactly what he looked exactly like what I thought. And after the case, the jurors thanked whoever it was who got rid of him off the panel. They didn't even like him. But you have to get them to be honest. It's a little bit easier now. You build a relationship with them. And I had something happen that I've never had happen before. In that case, it was self-defense. A UC student was charged with smashing a 40-ounce beer bottle on the face and head of another UC student. It was self-defense. And the issue was, based on the discovery, was the alleged victim going to give him a high five after a few weeks before threatening to have him shot and threaten him with a kitchen knife, or was he coming to give him a handshake? So I asked the jurors. I said, is there a difference if I approach you like this or come at you like that? And the juror reached out and shook my hand. Well, I didn't know what to do then. I couldn't be rude, so I shook it. And the prosecutor didn't know what to do, but that told me he's listening. They're participating, all right? I didn't say, will you shake my hand? It was a natural thing that happened. So you build a relationship, and you establish the expectations based on the evidence. One of the easiest examples of that is you have a client who you know you have to put on. You have no way to win a case if you don't. Don't you want to lower their expectations of him? Think of all the things that you can talk to them about using them as the subject. So when you came in here today as a prospective juror, were you nervous? Yeah, I was pretty nervous. And then you saw you had to talk in front of the whole courtroom. How'd you feel about that? I was scared to death, whatever. How do you think you'd feel if you were charged with aggravated robbery and your future was on the line if you had to testify? I'd be scared to death. And you can lower their expectations. And you can talk about that and go on and on. And the way it turned out, I put the client on. I thought he did horrible. I thought he was horrible. The bailiff thought he did a great job. The clerk thought he did horrible. The jurors thought he was phenomenal. He was obviously very nervous. He was very upset. He was very scared. And that's what they attributed to the nerves of the situation, because they weren't expecting any better than that. And you contrast that with what police officers who testify as part of their job might look like. Confident, calm, and so on. So, in terms of ethics and jury selection, where are we? What information is available? How can we find it? And how far can we go? When does investigation constitute improper contact? And what is our duty to investigate jurors? We're going to talk about the ethical obligations to research jurors' background, obligations of effective representation in voir dire, and our ethical obligations to disclose information that we might come across. All right, so we're going to start with social media. Social media today, as of a year ago, 500 million Facebook users, 600 million Twitter users, 150 Instagram, over 1 billion YouTube users a month. That's a lot of video. 2 out of 3 people with internet access use social media. So think about that for the implications of your 12 in the box. It means 8 out of 12 of them have some form of social media. The use, and this is even more important, is consistent. 2/3 is consistent across ethnic, racial, educational, socioeconomic backgrounds, with basically 2/3 of all of us use social media. That's a lot of information available to us. All right? I tried to make this a little bit more Pennsylvania specific, because I know you guys don't get great voir dire if you get any at all, but hopefully you will get something that will help. There's an opinion from the Pennsylvania Bar Association, its formal opinion 2014-300, that talks about the ethical obligations of attorneys for using social media. It's about a 20-page opinion. A lot of it is in terms of advertising, marketing, doing other things. But for our purposes, there's a couple things that are important. We'll come back to this in a minute. One of the things they talk about is social media is constantly changing area of technology that lawyers keep abreast of in order to remain competent. Remember what we were taught, probably even going back to law school, you have to be competent in the area in which you're practicing. Well, for criminal defense attorneys, you got to stay current on social media. It doesn't mean you have to be a genius and know how to do everything, but you have to at least understand it and recognize the import of it. So, what can we learn from social media? We can learn a prospective juror's employment history, political affiliations, religious affiliations, orientation, age, educational background, friends, acquaintances, hobbies. Hobbies is a big one. Hobbies can give you some information about people that you may not otherwise get that can be extremely important in whether you think they may or may not be a good fit in your panel. Let me see if I got this next. Yeah. So what are we allowed to search? You can use search engines. Google. There's social media sites. There's a website, a search engine called People, Piple.com. I don't know, in Ohio, a lot of the county courts, the courts have their records online, so you can search a juror's name, find out if they've got any kind of civil or criminal cases pending. Voter registrations. Accurate is a database that's owned by LexisNexis that gives you a compilation of all public records for a person. And when you do that, be sure and check name variations. There's different ways. These are just some examples. 2 ways you can spell Christie, Bill William. My given name is Ravert, but I go by J. You can find records under both. So you have to not get too confined in what you're thinking about. And read the juror questionnaires. I know the questionnaires are different every jurisdiction in terms of the information that you get. We're going to talk about what happens in a minute when you don't bother to read them. And don't believe everything you read. We still have, and I'm sure it's not unique to Southwest Ohio, some jurors who really want to be on the jury and really try to tailor their answers so they will stay. Be careful of people who look like they're volunteering. And pictures can be very important. Here's an example. I tried a murder case 3 years ago, and our defense was self-defense. It was a shooting case. We found this was a prospective juror on Facebook while we were searching while voir dire was being conducted. There were 2 of us in the courtroom. One of us was paying attention to voir dire. The other was going through the questionnaires, doing a search of each person's name on Facebook. Do you think this woman at all is going to have a problem with somebody being shot? Is she going to be afraid of guns? Is she going to be anti-gun? This is the kind of juror we were looking for. Unfortunately, we had really shitty facts. It didn't help much. But in the right case, it can make a big difference. So think about when you scroll through your Facebook feed and you see a picture and it, for whatever reason, it catches your attention, think about why it does. It might be because the person has the same kind of pet you have. It might be they're in a vacation or somewhere that you've been or would want to go. Pictures like that can be very important. A lot of times you'll get people who articulate a support or an adverse position towards different issues that are going on. Justice for whoever. Maybe you don't want somebody like that on your case on the facts you have. And that's the kind of stuff that you would never see in a questionnaire. You would never get the person to tell you, oh yes, I think this is wrong or this is the way I feel. You have to go find it. All right, so when do we search? In advance. In Cincinnati, in the state courts, you get the questionnaires that morning, so you don't have a whole lot of advance. Federal court, you can get them 2 or 3 days ahead of time. I don't know what the local practice is, but whatever time you have, take a few minutes. You can do it real time in court. Have somebody help you, set with you during jury selection if you don't get them until that morning, and they can start running the names. You'd be surprised how quick you can do it. After the trial starts, and there's some ethical issues about that, and in some states you have an affirmative duty to double check because of the technologies available. Do not do 3 important things. This is where you can get in trouble ethically. Don't violate somebody's privacy settings. If you see you have a common friend, don't have the friend look at the juror's profile or whatever and give you information you wouldn't otherwise be allowed to have. That would be wrong. Don't misrepresent yourself. There are some attorneys in the Southwest Ohio who've gotten in trouble for that. And don't ask a prospective juror to be friends with you. That sounds kind of commonsensical and obvious, but again, that's up there because somebody did it. Okay? That's where all this comes from. All right? So it gives us with 2 questions. Is there an ethical duty to investigate your jurors? And is there an ethical duty to investigate their responses that they give in voir dire? Kind of 2 different things. All right? Let's talk about the duty to investigate. There's not a lot of authority on this because in terms of legal developments, precedent, rules, so on, it's still relatively new. But in the state of Missouri, they have a rule of practice by the Supreme Court that requires counsel to investigate jurors' voir dire responses. You have an affirmative obligation to investigate them. In Alabama, if you're concerned, you should have checked available public records prior to, and this is the important part, during trial. Okay? Now, it's my understanding in Pennsylvania, the attorneys very seldom get to do much of the voir dire, if any, and it's all done by the court. And basically what you get is shit. But that doesn't mean at the end of the day, you can't go back and see what the jurors have said on their social media that may be different than what they said in court. The other thing it may give you is also the opportunity to go back and ask the judge to ask specific questions and make specific inquiries. And we'll talk a little bit about how important that can be if you find that information. In Kentucky, this was kind of an interesting case. It was in a small county. The parties did not have a duty to search Facebook after a juror responded, "No, I'm not on Facebook." And then they looked on Facebook and found out the juror lied and was friends with the victim's mom. That might be problematic if you knew it when you're picking a jury. But because there's no obligation, the defendant was able to get post-conviction relief when they found out about it. Okay? In Ohio, we don't have a specific rule, but we do have this. There's a first district case, which is in Hamilton County, that if you want to have file a motion for a new trial based on newly discovered evidence, it has to be evidence that you could not have found at the time with reasonable diligence. So if you want to take a step from that, we have all these search engines available, we have all this information out there, you have to be diligent and try to find it. Otherwise, you can't find it 6 months later and go, "Oh, my bad, I screwed up." So in Pennsylvania, what you have, this goes back to that opinion 214-300, and it talks about during jury selection and trial, and I think that's the important part, because that to me says it's ongoing obligation, ongoing right, and ongoing privilege. An attorney may access public portion of a juror's social networking website, but may not attempt or request to access the private portion of the website. Requesting access to the private portions would constitute an ex parte communication, which is prohibited. So it gives you have, I think, the opportunity and now the obligation, if you tie the competency requirement and a couple other things we're going to talk about together, to be affirmative in your checking of the jurors. Who knows, who can remember what the basis of the claim was in Strickland versus Washington, the case we always talk about for ineffective assistance? What did the attorney allegedly screw up in Strickland? Wow. No, you'll see why in a minute. This is very cool. The basis of it was failure to investigate. Okay? Must provide objectively reasonable representation in light of the circumstances. In light of today's technology and social media access and public records, do you have a duty to investigate your jurors now? So here, if you don't do the work, you don't do the background checking, you don't do the digging, you might very well have been ineffective and not even realized it. So that's the bad side of technology. We have a lot of information we have access to, but the problem is now we have to try to access it. So it's more for us. But keep that in mind, because I think that gives you an affirmative obligation to try to investigate these jurors that you have in your panel. All right? Now, here's what happens when you don't do what you're supposed to do. This is a questionnaire, and we haven't talked about questionnaires, but this is from a death penalty case that was out of Hamilton County in Cincinnati. They had I think a 26-page special questionnaire specifically for the capital case. The defendant was a black man. The child victim, I think, was less than a year old infant. This is, remember what I said about Trump giving people permission to be their asshole self? Question number 68, is there any racial or ethnic group you do not feel comfortable being around? Yes, please explain. Sometimes black people. Now, how many people, if you were the defense counsel, might follow up with that when you talk to that juror, right? Put your hands up. Everybody put them up, right? How many of you think that the defense attorney in this case asked word one about that? Said not a word. But that's okay, because he had a second chance. Because, you see, once a racist, you're going to be a racist on question 72 also. Some races or ethnic groups tend to be more violent than others. Oh, and this is a capital murder case of an infant, so violence might be an issue. I strongly agree. If you wish to do so, please explain your answer. Blacks. This person was in the first 12, stayed on the jury, convicted him, and voted for death. This case is on appeal in the Ohio Supreme Court based on, in large part, this. And you know what the state's response was? It was a defense strategy. Will you stop that? She laughed out loud. We are not that bad in Cincinnati. Come on. I'm serious. That was their argument. It was defense strategy. I don't know how you articulate that strategy. My point is this. Once you have information you can use, please use it. Because if I told you all of this and didn't show you that, you'd go, no attorney would ever be that stupid, right? None of you would believe it. But I'm serious. That case is pending in the Ohio Supreme Court right now. And the facts are horrible. So take any other factor out of it. They're just bad facts. All right, so you have a duty, if you find information, to disclose it. So let's say you pick your happy jury today, your judge is one of these, it's 9 o'clock, we're starting voir dire, and by 11 I want a jury. You don't have much time to do anything. But you go home and you do some research, and you find out that the jurors might have been dishonest. So now, strategically, what do? You put that in your pocket and set on it until your client gets convicted? Or do you have an affirmative obligation to disclose it? Remember, you guys are getting ethics credit for this. This is not a strategery session, okay? It's ethics. There's a case, United States, and I can't pronounce this name, DeGurtis. It was a huge federal fraud case. Had multiple co-defendants, and here, I'll just give you the scope of it for real quick. It was a 3-month trial, 9,000 pages of testimony, 40 witnesses, 22 million documents in discovery, 1,300 exhibits, 9 days of deliberation, and over $100,000 in jury and travel fees for the witnesses and the jurors, okay? So you get the scope of what we're dealing with. After jury selection, after the trial was going on, DeGurtis, however you pronounce it, his counsel became aware that one of the jurors had basically lied during voir dire. And it turns out that she was a disbarred attorney who, and I don't remember what the facts were, it doesn't matter for this purpose, but had lied during voir dire. He did nothing with it. He didn't tell anybody. His client was convicted. The Court of Appeals found this about the information that the attorney knew. There was sufficient information to determine the existence of falsehoods that should have necessitated further investigation and, importantly here, disclosure to the court. Okay? What happened was, after the client was convicted, he filed a motion for a new trial based on this. Anybody want to guess what happened? His new trial motion was denied. The co-defendants who didn't have the information, well, his right to an impartial jury was waived by the failure of counsel to disclose the information. The co-defendants who did no research, they all got a new trial because they didn't have the information, which kind of tells me you may not want to have him as co-counsel too, but that's a whole different story, right? Who wouldn't share that? So the point is, if you have information, you can't sit on it. And the reason for that, I think we all know, is it's policy-based. That would encourage us to have the information, sit on it, and then we can kind of cherry pick if we think the jury's going well or it's not going well, and we're not allowed to do that. All right? So that's the voir dire portion of what I wanted to talk about. Last week in Hamilton County, a sex case got reversed by our First District Court of Appeals on prosecutorial misconduct for 2 reasons. And the topic is ethically persuading your jury. We don't have a burden of proof, but the prosecutor does. I think part of our obligation as defense attorneys is to make sure they do their job ethically and within the bounds of the rules, right? So we're going to talk real quick about this case just as kind of a stepping stone for whatever the case law might be in your jurisdiction, but things we have to be better as a defense bar at looking at and seeing when they happen. Name calling and vouching, okay? This is a case that came out whatever day, the 24th. Randy Hall was charged in a 12-count indictment with sexually assaulting and abusing 3 different underage girls. Doesn't matter who they are. At trial, there was no physical evidence as to any of the counts. At trial, 8 of the 12 counts, the jury either found him not guilty or were dismissed by the judge at the end of the state's case. All right? So 4 counts were what went to the Court of Appeals. Not a strong case. All comes down to credibility. This case, the prosecutor, and there's a neat little backstory about this. The prosecutor, she decided, as we do sometimes, we label the witnesses, like the guy on the corner, the drunk under the bridge, whatever it might be. She labeled Mr. Hall a predator several times. Oh, and she called him a wolf, which I don't know what's so bad about that. I'm kind of partial to wolves, but the point being, this was her closing argument. All right? In the first district, in Hamilton County, we have a horrible history with the prosecutor's office. If they do what they want, and the Court of Appeals will say, you really got to stop doing this. It was wrong, but because of overwhelming evidence, you still win. We've been getting screwed like that for years. Well, the first district said, no, not anymore. So this name calling is now unethical. Now, what's interesting about this, the trial attorney who represented Mr. Hall is a phenomenal trial attorney. I've been doing this 30 years. Rich is, 35 or 40 years? Good trial attorney. He missed all of this. This was not objected to. This got reversed on plain error. So think about how bad it had to be. First, we know how hard it is to get a plain error reversal in the first place, right? But that's how strongly they felt about this. All right? But they do it in Hamilton County all the time. Dirtbag, scumbag, whatever it is. And the reason I'm bringing this up is not to embarrass the trial attorney, but as a reminder to all of us how easy it is to miss it. Okay? If you go, wow, that didn't seem right, it's probably not an object. All right? I grew up, I guess, a little bit different. I'm not all about civility in trials. I'm about trying to kick the prosecutor's ass. If they stand up and do this, I have no problem jumping on them with both feet. Oh, you're not supposed to object. It's not... Screw that. That's how we've gotten in this position in the first place. You have to watch for this. All right? Well, prosecutor was not content with this. Let me finish addressing this. This is where they address their findings. This is the court's opinion. The prosecutor's deliberate and repeated invocation of these terms was designed to inflame the jury. But the prosecutors on appeal said that the terms wolf and predator were within the permissible bonds under the circumstances, but they forgot something. In Ohio, when sex offender registration became the big nationwide craze, Ohio's first registration system had 3 different levels. The worst level was you were a sexual predator. That's what they called you. That was your label. And then the other thing that the first district talked about was right here. Remember datelines to catch a predator? And like I said, this is not a defense attorney who's not tried a case before. And he missed it. And he said, I don't know how I missed it. And we talked about it. And the only thing can be, we're just so used to not doing anything. So this is kind of like a vigilance kind of statement I'm trying to make. All right? And then I like this language. The state cannot demonize and even dehumanize a defendant with this type of name calling. We don't get language like this from our Court of Appeals very often. No purpose for such language in a courthouse erected to serve ends of justice. No purpose for that kind of language. Now, you'll be surprised to learn that the prosecutor's office was really pissed off when they lost this case. All right? You would think that's it, but wait, there's more. Not only did the prosecutor vouch or name call, but she vouched for the witnesses. She vouched for the credibility of the accusers by assuring the jury that they lacked the capacity to lie. Now, I have to admit, I probably would have missed this too. So, I mean, we all could have missed it. But here's what she did. Such statements that implied the prosecutor knew facts outside the record about the mental proclivities of the witness are improper. Okay? But it was really kind of subtle what she did. Here's what she did. Remember I said there were three girls? The girls don't have the capacity to continue on this year-long conspiracy against him. Give me a break. That, to be honest with you, didn't sound that bad. They do not have the capacity to carry on 3 independent accounts of sexual abuse by this defendant for over a year. All right? The girls came in here and did, I like the way she worded this. The girls came in here and did the best their little girl brain ability to tell you what he did to them. They don't have the capacity to form a conspiracy against the poor victim, Randy Hall. All right? And I don't know I would have picked up on it. But when you read it and you stand here and say it out loud, you're like, wow, that shit kind of hurts. So in terms of the ethics of persuading your jury, we have to be better at seeing this. Okay? And it's kind of tough because a lot of times this part of the argument comes after we've done ours. They get that little, yeah, I'm going to do my song and dance. The defense is going to get up and I'll be back. We sit down and we're like, oh, fuck, thank God that's over. Right? And we forget there's more to come. So I think we just have to be better at staying on top of it, all right? Prosecutors must not vouch for the credibility of witnesses. And again, whatever the law is in your jurisdiction, I'm sure it's something similar. But this is just an example, all right? Well, here, let me tell you about this a little bit more. The prosecutor in this case, this was not her first jury trial. She's been in common pleas, 4 or 5 years? Not her first case. Her father is also an attorney, very well known throughout the state. He came and watched his little darling daughter give this closing argument. Oh, I forgot to tell you. What's his job, Hal? He's on the Ohio Supreme Court. I'm not making this shit up. Okay? If you want more stories, just come visit Hal and I in Cincinnati. We got tons of them. Remember, that's where the judge got hauled off and dragged out of court a couple weeks ago. So we got all kinds of crazy shit. Her father came and watched this. You saw that, didn't you? Yeah? We make all the national news for all the wrong reasons. Her father came and watched and is a justice on the Ohio Supreme Court. And the prosecutor's office doesn't understand why they lost. And, well, we're going to appeal. Okay, appeal. You've only got 6 out of 7 who can even consider whether you get the case in. So, Dad saw nothing wrong with this. Dad now made himself a witness. Okay? And it's just kind of the way shit happens in Hamilton County. Go ahead, you can laugh out loud. It's fine. All right? So my point is this. We could all miss all of this. But you just have to take a second. And what I try to tell people is if it doesn't feel right, say something. Because there's a reason you're doing the trial work. There's a reason you're here. You have a feeling if something's not right. You cannot get hurt by objecting. The only way you hurt your client is by saying nothing. Man, I don't think so. Okay? And that's the kind of ethical lesson of watching them. We have to hold their feet to the fire and hold them accountable. It's not easy because if the trial's been a day, a week, or 2 weeks, whatever, you're worn out by that part. I get it, but we're not finished yet. All right? Anybody have any questions? How much time do I have left? None, right? These people can all go drink now and they still get their full hour of ethics. See, they like that better than anything I've said. I know what people's priorities are. No, she didn't get hauled out of her chamber. She got drug out of court after she was sentenced to 6 months in jail. Because she was convicted of an illegal interest in a public contract by giving her brother, who was employed by the juvenile court system, privileged and confidential information to help him in a employment dispute. She was our juvenile court judge. She's no longer a judge. Yes? I'm sorry, I didn't hear you. For the case that from Hamilton County? The reason that I gave you what I had is it doesn't have a citation yet. And what came out Friday, and I didn't get a chance to check this morning, it's State versus Hall, and the case number from the first district is C-17-0699. And it's from the First District Court of Appeals. If you want it, I can leave a copy with Gerald, or you can email me, whatever, I can send it to you. It's more as an example of what we have to be better at watching for. Who else? I saw another hand. You guys don't get your credit if we leave early, right? Okay, yeah. Really, you got no ethics questions after all of that? If I understand the question, if I heard it right, was earlier we were talking about vouching for our client and our witnesses, and where's the line between us vouching for our client witnesses and the prosecutor vouching for their witnesses? The rules don't apply equally to prosecution and the defense. And you're going to get ethics question or credit for this regardless of my answer. So here's my answer. I don't see there's a distinction. They can't vouch. We can. We get away with it. That's our job. Why would he come in here and lie? They can't say things that convey the impression they have knowledge that the jury doesn't. That's what vouching is. And they do it all the times with their cops. They do it all the times with their victims. Why would they come in here and lie? There is no reason. Why would the police officer make this mistake? There is no reason. That's improper. Part of our role as an advocate is to be an advocate for our client. They have a constitutional right to testify and put on a defense. The prosecutors don't have the same equal right. So ethically, I think there's a big difference. They can't vouch. We push the line, and if it's too much, let them object. That's my answer. Wow, that shut the crowd up, didn't it? Just like a fart in church, just like right there. I heard that once at a Christmas Mass. That was hysterical. Some little kid ripped one at a quiet time. I thought it was a joke up until then. It really happens. What else? Anything? I think with the development of social media and the law that comes with it, I think it's perfectly proper to ask, Judge, I've got an obligation to find out about these people. That's why I gave you the little nugget from Ohio that in Ohio, if you don't do the due diligence, you can't take advantage of newly discovered evidence later, and there you have the ability to do it. I know that, do you get a chance to give the judge questions in writing if you want them to ask? How much time, do you get time? Okay. Start with the most important thing, in my mind, and it's almost the same in federal court if you get any. In my mind, there's always one or two questions that you want to ask the jury that is essential for your case. If I said, sir, have you ever in your life had to defend yourself from being injured or hurt? Do I care what his answer is? Now they know what's coming, okay? Then get the information and investigate that night. That's why I gave you the rules, and I didn't look in New York, to be honest with you, but I think there is something from New York. Look that night, and you might find something and judge, we got a problem. And I think that's where the ethical component of this comes in. You have to do the due diligence to have tried. Then if something comes up later, your client doesn't get screwed because you didn't make the effort. But I think you have to make an effort to do that. In jurisdictions where you can submit written questions, I think the question from the questionnaire, if race is an issue in your case, is there any particular group of people you feel are more dangerous? If the judge doesn't want to ask that question, okay, you can't make them. But now you're making a record. And I think there are things like that where, in my mind, what you're trying to do is always make the judge do his job and make a fucking decision. And you may not agree with the decision, but every time they make a decision, it gives you something maybe to work with later. Does that make sense? And I think that's what we have to do is push them to do that. Quit being so easy to stipulate to this or go along with that. Screw that. No, I'm not. You want to prosecute somebody, you got to prove all of it. I'm not stipulating the venue. If you can't prove it was in the county, that's your problem. There's a judge that got mad at a defense attorney. How many times you get this? Will you stipulate to the authenticity of these cell phone records? Something like that. Most of the time, it's not an issue, right? Well, the prosecutor screwed up. They were coming from Kansas. They were Sprint, and they didn't bother to send a subpoena, and they weren't there. Defense attorney said, no, I'm not stipulating to it. And the judge had a fit. We have no obligation to help them. Well, that's the way you want to do it? Yeah, if they want to prosecute it, they can prosecute it. Don't expect me to help. And I think we have to quit doing that. And I'm sorry? Absolutely not. So I'm like, do unto others and kick them in the nuts. No, I'm serious. You know, we talked about building relationships with jurors and talking to them. And in the trial with the UC student with the beer bottle, the juror shook his hand. I didn't know what to do. I didn't want to be rude, so I shook his hand. And the way we do peremptory challenges, 2 or 3 challenges into it, the prosecutor said, now, Mr. Clark he tries to make a real point of connecting and, you know, having a conversation with you guys. I'm not really good at that. Yeah, we know. Afterwards, when I talked to them, the one guy said, I know he made fun of you for that. And I didn't care what he said after that. It didn't matter. Because they picked up on, I was being genuine and sincere in trying to talk to these people. And the prosecutor wasn't doing it. And that's what you have to try to do if you got 5 minutes or 15 minutes. The one thing we do get in Hamilton County that's pretty good, we get pretty good voir dire. I've taken co-defendants 3 days sometimes to pick a jury. And the judge got mad, and I wouldn't necessarily recommend this. We were supposed to go on a jury view at whatever time it was. Yes, Judge? If you don't hurry up, we're not going to be able to get on the jury view at 9 o'clock tomorrow. That it? Yeah. Ma'am, if you were here sitting next to me and I was representing you, would you want me to hurry up and just finish my voir dire just because we had some deadline? That was basically it. No, I'd want you to take as much time as possible. And I'm looking at the panel, and the judge is turning beet red, and the other attorneys are going, I can't believe you asked that question. But what can they say? Right? Now they know the judge isn't trying to be fair. And it goes back to who's running the courtroom. My attitude, for better or for worse, is it's my courtroom. I just let the judge come sit there and be in the way, and the prosecutor has no choice but come. It's my courtroom. How many of you ever just said, stop them? Judge, can we stop? I got to pee. I don't know about the jury, but I got to go. Right? Well, you're laughing, but you're thinking of them. You're being conscious of them. That's who you want to look to you. And it's little things like that that do that. I tried a murder case, and I didn't feel bad. The prosecutor was a dick. There was a team of prosecutors, a man and a woman. And the woman is kind of a tiny, slight-built person, Ann Flanagan. And for whatever reason, we're in a room. It had a big podium. It was heavy. And where it was blocking the juror's view of the witness stand. And I watched the guy prosecutor sit at the table and watch his co-counsel try to wrestle this podium out of the way in front of the jurors. And they're looking at her and looking at him and looking at her and looking at him. They're going, you're an ass. Get up. And I wasn't going to help her. Not my job. But they pick up on all of that stuff that never shows up in a record. You never read about it. It's amazing what they pick up that is not ever part of the case. I had a stalking case. One Cincinnati cop charged the other with stalking. Yeah, we got some problems. This woman testified she was scared to death of my client. And she's sitting in a jury stand like right here. And we take a break. And it's a small courtroom. And the jurors are like right here. Stand up and stretch, and the judge had to sign, so I don't know what it was. And my client, without even thinking about it, gets up, walks over to the only trash can in the courtroom, which was right here, and spit his gum out. Came back and got at the table. All right? I saw it. I didn't think anything of it. Apparently, this alleged victim was traumatized by that. And so the prosecutor asked to reopen the redirect so they could ask about it. I'm like, okay, fuck it, go ahead. So they did, because I watched every juror watch what happened. They lost the case right there. I didn't know it at the time, but they lost the case right there. We went back and talked to them. They said, the one guy said, I didn't know what to believe, but when the defendant got up and threw his gum down and she just sat there and looked at him, she wasn't afraid. You never know what they pick up on, and you always have to be aware of that. Take advantage of it.